Hi, I'm Jennifer Campbell, one of the co-chairs of the Beverly Hills Bar Association Trust and Estates Section Executive Committee. Welcome to our program today, T&E Ethics for Practitioners in the 21st Century. Before we get started, I need to make a few announcements. You will receive your MCLE certificate materials and a copy of the program in about a week. After the program, please take a moment to complete the survey. The survey link will pop up right after we conclude the webinar. And now I want to give a shout out to our sponsors. The Trust and Estates section and all of its webinars are sponsored by the Sanborn team, Geffen Real Estate, Glen Oaks Escrow, and California Title Company. First, I'd like to introduce Nancy Sanborn and Brian Joy of the Sanborn team.
Hi, everyone. Good afternoon. We just want to ask you a quick favor. Normally, this time of the year, we do a special drawing for a donation for the food bank, and normally we draw a name and someone tells us which food bank. But this year, we've put into the chat system a couple different food banks. So if you guys would vote for the food bank, the one that receives the most will get the donation.
The Sanborn team has been privileged to serve our real estate clients for over 40 years.
We represent residential as well as commercial assets.
We serve clients in Southern California and collaborate with agents throughout the United States.
Our clients come first, and our focus is on obtaining results.
From attorneys to fiduciaries and administrators, we have systems in place to make sure your clients' needs are met.
When you hire the Sanborn team, you are joining thousands of satisfied clients.
Your continued support has made the Sanborn team the #1 choice in trust and probate real estate. Thank you.
Thank you, Nancy and Brian. And now I'd like to introduce Orit Gadish of Geffen Real Estate.
Thank you, Jennifer. I hope you enjoyed today's presentation on ethics. It's my favorite topic, doing everything you can to do good and not cause harm. As a broker with a team of over 20 agents throughout Southern California, I keep it top of mind to make sure that every day we are all taking actions that are not only within legal guidelines, but that are also ethical. One of the pet peeves I have is seeing properties on the market for a very limited period of time. Some properties are only on the market for 3 to 5 days. That's a red flag for me. I wonder why an offer was accepted so quickly. I always make sure my listings have sufficient exposure and on market to ensure engagement. Wishing you all a happy Thanksgiving and looking forward to connecting with you soon. Back to you, Jennifer.
Thanks, Orit. And now I'd like to say a few words about our other two sponsors. Marcine Klein is a full-service escrow officer specializing in probate, trust, and conservatorship sales, both court and independent administration of estate act transactions at Glen Oaks Escrow. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that her clients are beyond happy with their experience at Glen Oaks Escrow. California Title Company is also one of our sponsors. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. Thanks to our sponsors. And now I'd like to, and I am pleased to introduce one of our Legal Update co-chairs, David Shapiro, for our Legal Update.
Thanks, Jennifer. Of the two propositions on the California ballot related to real property taxes, only Proposition 19 passed. Proposition 19 will add provisions to the California Constitution to do the following. Effective as of September 16th, 2021, in order to qualify for the principal residence exclusion, the receiving child must use the residence as the child's own principal residence, and the exclusion will not be unlimited. Instead, it will only exclude the first $1 million of assessed value. It also eliminates the parent-child exclusion other than the principal residence. Effective as of April 1st, 2021, it allows eligible homeowners to transfer their tax assessments anywhere within the state and allows the tax assessment to be transferred transfer a more expensive home with upward adjustment. It also increases the number of times that persons over 55 years of age or persons with severe disabilities can transfer their tax assessments from 1 to 3. There are 2 recent cases of interest. The first, Gomez v. Smith, Court of Appeals case C089338, 3rd District, filed September 22nd, 2020. After Frank Gomez and Louise Gomez rekindled their love late in life, Frank attempted to establish a trust for the benefit of Louise, but Frank's children intervened and prevented Frank's attorney from entering Frank's home. The decision provides an analysis of the elements of the tort, tortious interference with prospective inheritance, and also discuss the mental capacity analysis under probate codes section 810 through 812, as opposed to probate code section 8100.5, in which in cases where the estate plan is more complex than a simple will or a codicil. The court held that even though the plaintiff had a duty to prove that they would have inherited but for the interference, the burden of proof of capacity generally falls on the person challenging the trust instrument. So in Gomez, the burden to prove the incapacity fell on the defendant. The other case is conservator of the person of SA, Court of Appeals case B302038, 2nd District, filed November 3rd, 2020. SA's mother petitioned to be reappointed as SA's LPS conservative of the person and to have the power to force SA to take psychotropic medication against her will. SA objected. Evidence conservatees lacked insight about their mental illness, would not take medication without the support of a conservator, and could not provide for themselves without medication is enough to support a court's finding of grave mental illness. A court may order involuntary medication if clear and convincing evidence shows the conservatee is incompetent to give or withhold informed consent. The court held that even though a psychologist may not prescribe drugs, they may still be competent to testify of the proposed conservatee's incapacity to make rational decisions about medical treatment. Thank you. Kevin Harrington will be introducing our esteemed speakers for today.
Thank you, David. Hello and welcome. I'm one of the program co-chairs of the Trust and Estates section. Today, we are fortunate enough to have Heather Rosing and Ann Rudolph presenting to us about ethics, risk management, and legal malpractice considerations for trust and estates practitioners. Heather is a shareholder with Clients to PC. Heather chairs the firm's professional liability department, litigating complex malpractice and fraud cases, advising in the areas of ethics and risk management, and serving as an expert witness. Heather is a certified specialist in legal malpractice and a former member of the ABA Standing Committee on Lawyers' Professional Liability. She also served as an appointed advisor to the Rules Revision Commission of the State Bar of California, which recommended wholesale revisions to the rules of professional conduct. Heather served as the inaugural president of the California Lawyers Association. Previously, she served for 4 years on the California State Bar Board of Trustees as vice president, treasurer, and chairperson of Regulations, Admissions, and Discipline Oversight Committee. Ann is a shareholder at Hughes & Pizzuto, a boutique firm focused on trust, probate, and tax matters. She is a graduate of the University of California at San Diego and received her JD with highest honors from the University of Oklahoma College of Law. Ann is a certified specialist in estate planning, trust, and probate law, and her practice is limited to trust and probate administration and related litigation and appeals. Ann was the vice chair of the estate planning, trust, and probate law section of the San Diego County Bar Association in 2007, and a member of the San Diego County Bar Association Legal Ethics Committee from 2015 to 2018. We will try to answer any questions you may have with the question box at the bottom of your screen. And now I will turn it over to Heather and Ann for our presentation. Thank you.
Well, thank you so much for having us today. Ann and I are very excited to be here. Ann and I go way back, and we've taught a number of these together, and it's a nice intersection given our respective practice areas. So, we hope you find this enjoyable, and if you have questions even after the program, feel free to reach out to me and Ann. We'd be happy to speak with you. So we entitled this, as you can see, is T&E Ethics Practitioners in the 21st Century, Age-Old Issues in a New Environment. So times are changing, as we certainly all know, but the issues remain the same. So we're going to go over some of the ethics rules, and we are going to give you practical tips on how to conduct yourself in light of this, new yet age-old environment. So first, Ann and I are going to talk about scope of representation. And as Ann knows, she's going to jump in, and we're going to kind of go back and forth and try to make this dynamic and interesting for you over the course of this 1 hour CLE. So one of the most critical things that you can do as a practitioner in today's day and age is go through a very careful intake process and ensure that you are clear on exactly who is your client. And this is our second slide here. I think Ann is getting back to that. And, you would think this wouldn't be a huge issue. Who are you representing? Who is the client? But indeed, it is a big issue in a lot of legal malpractice cases, as I can attest to having spent 25 years defending lawyers in legal malpractice cases. I gave Ann the example of the LLC context, where a lawyer is representing a limited liability company, and there's allegations that the lawyer also represents the individual members. Sometimes there's a husband and wife team, and the question is whether the lawyer represents the husband and the wife or both. Sometimes there's a corporation with a principal, and the question is whether the lawyer represents the corporation and the principal or just the corporation. These issues, as Ann will discuss with you, are particularly poignant in your particular practice area, and Ann is going to go over that with you in some detail in the next slide. Let me just comment, though, that one of the obvious practical ways of pinning down who is and who is not your client and the scope of your representation for that person is to ensure that this is carefully documented in your engagement agreement. Engagement agreements aren't mandatory under the law. If you don't have an engagement agreement, it means that you're limited to the quantum merit value of your services pursuant to Business and Professions Code 60, I think it's 61, 57, and 5168 or thereabouts. But even though it may not be mandatory for you to have an engagement letter, this is the prime opportunity for you to say who you represent and what you represent them in. There's a famous case from a couple of years back, a legal malpractice case, that talks about a lawyer who did not effectively limit the scope of his representation. He got it right in his engagement letter as to who the client was. But he stated in his engagement letter that he was providing workers' compensation services, but he didn't disclaim the fact that he was not assisting the client with third-party claims that arose out of the accident. And this case went up to the Court of Appeal, and the gist of it was that this lawyer would have been able to limit the scope of his representation had he specified that in his engagement letter, but he didn't effectively do so. And you guessed it, what happened in that particular case is the statute of limitations ran on the third-party claim, and this poor workers' compensation attorney was blamed for that. Ann and I discussed the fact that if you have a particular scope of service, you state it, and then you can have a list of exclusions from the scope of your services. You don't represent them with regard to this ancillary matter or that ancillary matter. Your representation ends at this particular point in time for this particular client. So please pay close attention to this. The first thing that I do whenever I defend a legal malpractice case is look at your engagement letter and your conflict of interest waivers. And it's unfortunately, somewhat surprising how these documents across our profession tend to be, not entirely up to snuff. I think a lot of lawyers rely on legal assistance and rely upon paralegals to help put together engagement letters and conflict waivers, but this is something you need to give your personal attention to. So with that, let's go to the next slide, Anne, so you can talk a little bit about this critical issue of who is the client and what is the scope of representation in the trusts and estates context.
Right. Thank you, Heather. So good afternoon, everybody. I just want to say I think that, you know, a lot of us get into the trust and estates practice area because we want to help people. I hear that over and over again, is especially people who do estate planning. They're not interested in conflict matters. They're interested in just trying to help people set up their estate, set up their assets for passing on to the next generation so their wishes are met. But this area of the law really has more potential conflicts and actual conflicts than probably any other area, because especially for estate planning, you are frequently representing joint clients. You might be representing different generations of families. Even in admin and litigation, you may have multiple clients, multiple beneficiaries, co-trustees. So you really need to pay attention to these conflict issues very closely. But the scope of the representation, it's very clear that the client is the person signing documents. So if you're doing estate planning documents, the person signing the documents is your client. But it is not uncommon for there to be that the client is brought to you by maybe somebody who's already your client. Their son, for instance, brings in mom, wants to have some documents done, and son may be paying for it, which Heather and I are going to talk about in a little bit, about who's paying the bill and how to address that. But I think the engagement agreement, as Heather was saying, engagement agreement is so important. Define who the client is, what capacity you're representing them in. That is also a key thing, so that there's no confusion. If somebody is a beneficiary and a fiduciary, make it clear, I'm representing you as trustee and not as a beneficiary. About excluding things, I mean, set out the scope of, even if it's a standard estate plan, you might consider writing in what documents you're going to prepare for the people. Putting in whether you are going to provide any advice about tax matters or investment matters. It's certainly in litigation engagement agreements, you want to put in there whether the scope of the agreement includes an appeal, if there is an appeal in the course of the litigation. So these are all things that are easy to do at the beginning before there's ever a problem, and you want to do that. You want to make sure that you have that in there so that you're not stuck with any kind of confusion about these types of things. Who is my client and what is the scope of the representation I'm providing to them? And
can I just add, I forgot, this ties in nicely to your point. You know, Anne's talking about how you define the scope of your representation and really limit the scope of your representation. On the previous slide, we gave you a reference to Rule of Professional Conduct 1.2. The rules of professional conduct were actually revised effective November 1st, 2018. And subsection B of 1.2 allows you to limit the scope of your representation. It explicitly says it's ethical, so long as it's not prohibited by law and the client gives the informed written consent to that. But informed written consent is the key. The client needs to sign that document and have an opportunity to consider that document that sets forth that limited scope representation in order for that consent to be valid. Anne, back to you.
Right. So on this slide, we have some of the really common, I think, communication issues that you want to deal with. So the idea of the family attorney. This used to be a really common idea in the law. So I'm an estate planning attorney and I am representing, quote, the family. And obviously that is not the case. You need to really make it clear who you're representing. And it's not uncommon. I mean, at my firm, it's very common to represent the parents, and then the parents are happy with the services, and so then they refer adult children and their spouses. These things, as we all know, are very common, and so you just need to really make it clear who your clients are, and these are separate representations, which we'll talk about, but there's no such thing as just the family attorney. You may represent multiple members of a family, but those are all discrete representations, and you need to make that clear to all of the people so that they don't all just think that it's a free-for-all and they can call you up and talk about things. Certainly this comes up, I think, a lot in my firm with family businesses. So that's another part of making sure your engagement agreements are clear. If you're just doing estate planning, but the family also has a business, and there clearly is overlap in family business planning and estate planning. So just really make it clear what services you're providing and to whom you're providing them and who you're sharing information with. The next one is the idea of the estate's attorney. I hear this almost every day. I'm sure that you do too. You hear every day, you're the trust's attorney, you're the estate's attorney. Lay people commonly believe this, that especially if you were mom's attorney, for instance, a mom has died now, son who is the trustee comes to you for representation, the other children all look upon you as their attorney, that you're the attorney for the trust. You were mom's attorney and now you're doing the administration for everybody's benefit as mom wanted you to do. So it's really important to correct people and make sure that they understand who you are representing, what your role is at this point. I recommend even in a trust admin, when you send out the 1606 1.7 notice, send a cover letter with it and make it really clear who you're representing. I'm representing the trustee. I don't represent any of the beneficiaries. If you have any questions about this or anything else, please consult your own attorney so that right from the get-go, they're understanding what your role is. And even clients, I mean, I have many clients who are lay people who they even think that I was mom's attorney and now I'm just helping them to administer the trust, and that basically I'm looking out for the interests of everybody. And you have to just constantly make sure people understand, because in this area of law, unlike, say, a personal injury action where it's really clear, you represent the plaintiff and there's a defendant and that's it. In this area of the law, particularly when there is no conflict, which is not most of my matters are conflict matters, but an admin where there's no conflict, everybody just kind of thinks like, oh yeah, we hired this lawyer and this lawyer is helping us in order to do the admin and distribute out the assets. So in order to avoid those misunderstandings, please just make it clear, continue to repeat it. Every time I send an email to a beneficiary, for instance, I repeat at the end of it, just a reminder, I represent the trustee only. I don't represent you. While I'm happy to answer general questions about the status of the administration, if you have any question about your rights and entitlement, please contact your own attorney. It's just a really good practice to do that. And as that case that we cite there shows, the duty to communicate includes making sure people understand who is and is not your client.
Two wrap-up points on Ann's really excellent presentation there on slide 3. First, I wanted to give you the correct, accurate citations to the Business and Professions Code sections that deal with fee agreements. It's Business and Professions Code 6147 for contingency fee agreements and Business and Professions Code 6148 for hourly fee agreements. So when you're putting together your fee agreement, you can look at these provisions that I just cited to you. You certainly should be, hopefully taking into account the advice we just gave you about defining the client, defining the scope. And also, there are a variety of other resources for fee agreements that can help you. For example, the State Bar of California has some form fee agreements. I was involved in drafting some of those iterations a number of years ago. Some of your professional liability carriers may have form fee agreements. But again, a form is just a starting point. It's not the ending point. You got to customize. Yes. And the other thing I wanted to add, just to piggyback on Ann's point, it's really interesting. She talks about how, when she sends the notices to the beneficiaries or emails, she says, I don't represent you, I don't represent you. That's the same advice that we give to our business lawyer clients, again, who typically will, represent a LLC or maybe a partnership. And in the operating agreement, for example, for the LLC, we recommend there be a statement. I, the attorney, only represent the LLC. We don't represent you as members. You need your own counsel. And then the same thing in subsequent email communications with the members, which will happen. So this general advice Ann gives in the trust and estates context actually transcends practice areas. So with that, Anne, did you have any follow-up points there?
Well, I just wanted to say on the form fee agreements, also ACTEC has form fee agreements that you might be able to access since those are trust and estates specific. Even though ACTEC's a national organization, they have excellent information.
Thank you. Yeah, I was telling Ann, I gave an ABA presentation in 2017 at an ethics conference in St. Louis, and I presented with a couple of ACTEC leaders. I learned about these resources and looked them up, and wow, ACTEC provides a lot for free. I really am not aware of any other trade organizations that offer that depth of material in terms of ethics and risk management and fee agreements. So check it out for sure. It's pretty cool. They have this whole compilation of all the case law across the states about how attorneys could have liability in the trust and estate and probate arena. So you can literally review the law in all 50 states on
yeah. And the other thing is, so the ACTEC guide on ethics, which is available for free online. I highly recommend it if you have never accessed it. It's extremely well done. I believe the last update was 2016, but one of the things that makes it even more helpful for us as California lawyers now is because of the complete revamp of the California Rules of Professional Conduct, and they now use the numbering of the model rules, which almost every other state, if not every other state, I don't know, Heather, I think every other state was already using their rules, using that same numbering system, following the model rules, because a lot of states just adopted the model rules wholesale. They didn't even do anything special, but California was always special, and we had this completely different numbering system to our rules where it was not hard. Oh, sorry, my lights just went out. It was not necessarily easy to kind of correlate, okay, well, rule 1.7 was rule 3-100. So now that the numbers are the same, the ACTEC guide is even more helpful, and it provides excellent commentary. And like Heather said, case law from all around the country, which even if it may not be precedent in California, is certainly very helpful when you get to some of these sticky ethical issues. Because not every ethical issue is going to go into court, and they come up, and it's really great to have these resources. So the fact that we've now renumbered the rules makes it easier to utilize the ACTEC guide as a helpful resource.
That's a great point. Excellent. Well, turning to slide 4, we have a total of 10 slides. We kept them simple so that we wouldn't overwhelm you with visuals, but we hope you enjoy the combined presentation of the verbal part of it with the slides. So conflicts of interest. I feel like I live and breathe this topic every day because it's really the subject of so many risk management issues that I get from my lawyer clients. It's certainly the subject of many malpractice cases, certainly the subject of many state bar complaints. The conflict rules are complex. There's just no other way to put it. You know, we are a profession of complexity, and it's really funny if you compare the conflict of interest rules for accountants set forth in the AICPA professional conduct rules with our conflict rules for our profession. It's just a vast difference. You know, the accountant one, I'm going to, simplify for presentation effect here, but says something like, thou shalt not be conflicted, whereas we have hundreds of cases and ethics opinions that interpret what is now Rule 1.7, which I'm going to talk about in a second. So conflicts of interest. The first thing Ann and I wanted to present to you is joint representation conflicts of interest. And as you've heard many times now, we've changed our rules of professional conduct. So we now have the practical equivalent of Rule 1.7, which was the ABA rule, model rule, and is now the California rule. And the old conflict rule 3-310 in California made this distinction between a potential and an actual conflict, and nobody knew what that meant, and it was confusing, and so we got rid of that. The Rules Revision Commission and the Supreme Court got rid of this distinction between a potential and actual conflict of interest, and instead we now focus on, in the joint representation context, if there is a significant risk of material limitation. So as you are assessing whether you can represent two people in a matter, whatever the matter may be, and Anne on slide 4 gave a couple of examples, including multiple beneficiaries, multiple fiduciaries, husband and wife would be another common one. You have to look at whether there's a significant risk of a material limitation. And if there is, then you need informed written consent, which is the fancy term for a conflict of interest waiver. Conflict of interest waivers need to be done by lawyers, not paralegals, not secretaries, because it's important for you to describe what are the potential points of conflicts and essentially the risks inherent in joint representation. I have for many years recommended to my clients who are lawyers, if you have joint clients, you may want to consider informed written consent, even if you're not 100% sure that there's a significant risk of a material limitation by virtue of the joint representation. Certainly no harm can come of it, and it's a good way of the clients appreciating the risk of joint representation. Last night when Ann and I were preparing, we also discussed at some length this confidentiality issue. If the evidence code says that if joint clients are in a dispute, there is no privilege as between them. But you don't want to wait for there to be a dispute among joint clients for the confidentiality or privilege issue to come up for the first time. That's no good. So your conflict of interest waiver, and I'm going to turn this over to Ann to add a little color to it, should really describe what that means. What are you going to keep confidential? What is the sharing between the joint clients? What happens to the file if one person requests it? Ann, you want to add a little bit to that?
Well, yeah, I think Heather and I discussed that we both have the same approach as a default, which is there is no confidentiality among joint clients. And so it's important to make that clear at the outset. I put it in writing. I recommend putting it in writing at the outset. But this comes up, and this has happened in my own firm, and I'm sure it's happened to many of you. The standard joint representation for an estate plan, of course, husband and wife estate plan, couple estate plan, and they come in and you're meeting with the couple together and you're moving forward and discussing their estate plan. And maybe sometime later you get a call from the husband who wants to inform you that he has a girlfriend and that he wants to make arrangements for his girlfriend, and you can't tell his wife about it. And so what do? Now you have a major conflict, and I would suggest if the husband if he insists that you can't tell the wife, that's something that is material to the representation, especially if he wants to make some kind of gift to the girlfriend. And you probably can't go forward if he insists that you can't tell the wife that. So one consideration is at the outset, meet with husband and wife briefly separately, let them know if you have something that is a secret and you don't want to come out, we're not going to be able to go forward because this is a joint representation and we don't have any secrets in this representation. So in my own firm, this happened with one of my partners. He was meeting with a husband and wife, first client meeting. Wife excused herself to go to the restroom, and when she was out of the room, husband said, hey, you know what, I have an affair, I have other children, and what are you going to do when you get to that point? So that is something that even, I don't know if you can even start talking about it before you meet with people, but certainly you have to, at the very outset, start talking about this. And informed, what does informed consent mean? Is something else to consider is, put in the details of what the potential conflicts are. Don't just say there's a potential for conflict when you have joint representation. Give some examples of common things that may happen. For instance, with multiple beneficiaries in a litigation matter, I list out, while your interests are aligned and right now we don't see any conflicts, it's possible as this matter goes along that you will have disagreements, or that one of you may want to settle the case right away. One of you may not. One of you may wish to make some assertion of a creditor's claim and the other one then does not. There's so many potential examples, but you have to look at each case. Don't just have for instance, a boilerplate conflict waiver, like Heather said, make them specific, work on it yourself, and think of each case and what is going on in that case and what conflicts you can envision as potential conflicts. And then, of course, if an actual conflict does arise, the things that you envisioned or something you didn't, do a new conflict notice. We now have an actual conflict. Here's what it is, and have everybody consent to continued representation if they wish to, if it's a conflict that can be waived. Most conflicts can be waived with informed consent. But sometimes something comes up where you just can't, you can't, if the people won't agree and come back around, you may have to withdraw, and that's part of it too. If a conflict arises, are you going to continue with one of those clients? Are you going to withdraw altogether and send both of them out to get 2 new lawyers or 3 new lawyers? Really address all of those things at the get-go. So the same with multi-generation representation. That's an interesting one. That goes back to the idea of I represent the parents, they refer clients, now I represent the kids. I was talking to, when I was on the San Diego Legal Ethics Committee, there's an attorney here in town who is, I don't know how old he is, but he's been around for 40, 50 years. Very, very well known, very, very knowledgeable about these things. And he and I were walking to a meeting one day, and he was telling me about his own estate planning. And he was telling me about the fact that the attorney who was representing him, who I knew, who's very, very reputable, very good attorney, and he was saying, oh yeah, he had done my wife's and my estate plan, and then my wife's mother died, and then he was representing my wife as trustee, and then he was representing my wife's brother and her and his wife, and that all of those representations, there was not a single conflict notice that had been sent out. There was no conflict waiver. There was no nothing. And this attorney was chuckling. He was just laughing about it. But I was kind of shocked in this day and age that there was, with all of those relationships of representing people for estate planning, then a subsequent administration, and then one of the beneficiaries is already your estate planning client, and not having done any kind of conflict waiver was kind of shocking to me, especially with this attorney who I know well, who is very, very good. So that experience told me these things need to be repeated over and over again. Some of you may think, of course, this is a no-brainer, but for some reason, it gets kind of lost in the shuffle. When you're signing up a new client, sometimes it gets lost in the shuffle. So don't let that get lost. So Heather, on the multi-generation representation, what really are the differences, in that and joint representation?
There are some significant differences there. And let me make one, thank you, Anne, for that question, which you decided you would ask me last night, which was totally pre-planted. So it's all designed to flow in a way that's interesting to you as our viewers today. But I did want to make one other, but I will answer that question in a second, but I wanted to make one comment to tag on to Anne's comment about, what happens if you have the conflict waiver and then a conflict arises and you think, well, maybe now they all need new lawyers, or one can stay with me, or, what do I do? How do I rejigger the representation such that it's ethically compliant? I want you to keep in mind that California does allow advance conflict waivers. And so I'm not sure how this would work, effectively in your practice area, but you can think about it. But it is essentially, let's say you're representing, 2 people in litigation, and one is a long-term client of yours, and the other is a new person introduced to you by the client. And you want to take on that joint representation in the litigation, but you don't want to be in a position ever where you may have to withdraw from the representation of your long-term client. The conflict waiver can say that the new client, the new joint client, waives the right to essentially disqualify you or claim a conflict in the event that that person has to be referred to new counsel. In other words, in that scenario where an actual conflict arises, you can continue to represent only the long-term client. It's a case called Zador, Z-A-D-O-R. It's used particularly in the big firm context when they represent a lot of corporations and There's a lot of complexities to their conflict analyses. Advance waivers can be very important, but I did want to make that point. Turning to multi-generational representation and how that works with joint conflict waivers, here's an important distinction that Ann and I have been discussing. We just told you about how it works if you represent joint clients in a matter. So you are representing, for example, two beneficiaries with regard to some type of trust context. You know, you're a group together with regard to that matter. But it's different if you are, for example, representing one generation with regard to estate planning, and then other people in another generation or another branch of the family with regard to their estate planning. Is that considered joint representation? Let's think long and hard about that. Well, I think it would be best not to characterize that as joint representation, even though they're part of the family, same family. Those are two separate representations. And because of that, you would want to make it clear, and Anne, I know, does this as a matter of course, that you are not going to be sharing information from this separate representation of somebody else in the family. So you represent mom and dad with regard to their estate planning, and then you represent mom's brother and mom's brother's spouse with regard to their estate planning. The documentation that each sign will state, hey, I do represent your other family members in a separate matter, and everybody has their confidentiality related to those separate matters. I am not going to be sharing with you what I learned from mom and dad here or from brother and brothers, from the other relatives over here for that separate pod of representation. So that's different. So think about it. When you are considering what you think may be joint clients, consider whether they really are or whether they are simply separate engagements of related people, such that it becomes important to define them as such and to make it clear you will not be sharing their confidential information.
And this is a real life situation that can arise, and Heather and I are familiar with a case where it was a litigation matter that my firm was handling, representing surviving spouse in a trust contest filed by children from first marriage. And that was going on for some time. And then in the midst of that, a malpractice case was filed against the estate planning attorney who Heather then represented. And the nature of that litigation, the malpractice case, was that one of the children from the first marriage sued the attorney, and Heather can clarify or fill in, but basically the gist of it was that dad had amended his estate plan and her interest in the estate plan had been diminished in favor of stepmom. And she and her husband were also estate planning clients of this same attorney. And the allegation was, you owed me a duty to let me know that my dad had changed his estate plan and that it affected my interest. And that is, I mean, of course, we disagreed. Heather defended the attorney successfully, but that issue could have been avoided from the get-go if the engagement agreements for all of those people had specified, I represent, if that engagement agreement for that person had said, as you know, I represent your father and his wife, and I handle their estate planning, and I'm not going to be sharing anything that happens in their estate planning with you, regardless if it impacts your interest or not. And so that would be something that you should consider doing if you're doing multi-generation representation, is really clarifying that these are separate engagements, and the fact that you all know each other doesn't make any difference. And we're not going to be sharing, just like I wouldn't share with any stranger clients that I have.
And the situation is very complex in those scenarios. It touches not only on issues of confidentiality, but it touches upon the prohibition in Rule 1.7 that you can't be adverse to a current client on anything. So, the scenario that Ann described, I've handled maybe 7 or 8 malpractice cases with that exact same scenario. And the allegation has to do with the confidentiality, but the allegation oftentimes is, you just can't help dad amend his estate plan in a way that hurts me because I'm a current client with regard to my separate estate planning. You can also deal with that situation by way of advance waivers, where you make it clear you're not only going to not share information, but they waive any conflicts with regard to your representation of the other, because even adversity to a current client can be waived according to Rule 1.7 with informed written consent. With that being said, though, as a risk management tip, if you really find yourself in a situation where one of your clients in the family is going to become openly adverse to another client, perhaps through an amendment to the estate plan, you may want to think twice about whether you want to really be in that situation. And you may want to refer the client to somebody else quite candidly, because that litigation after the fact can get pretty nasty, as I think everybody on this call knows.
Right. And that segues right into our next slide, and the common scenario where you were representing the decedent, you were the estate planning client for decedent, now decedent, the successor trustee, for instance, comes to you, wants representation. One of the children who's a beneficiary comes to you, wants representation. So there's no conflict in that situation. Your former client is now deceased, and so there's no problem with you representing the successor fiduciary or one of the beneficiaries. It's extremely common. I'm sure everybody on this call has done it many times. But one thing to consider is if there is a problem. I generally see most attorneys, estate planning attorneys, if they take on the representation, for instance, of the fiduciary, and let's say there's 3 children, one of them is the fiduciary goes to attorney, they take on the representation, then one of the other children starts making noises, starts complaining, starts indicating that there may be a problem. The better choice is to get out of that situation if it's going to be a contest. I mean, it's one thing if they're complaining like, when are you going to sell the house? Those types of things. But if it starts to be in looking like there's going to be a contest and you were the estate planning attorney who drafted that document, I would say it's not advisable to stay in that case and represent one of the parties. It's actually not a prohibition. It's actually not something that you could be disqualified for. I had a will contest case where the drafting attorney came on and continued to represent one of the beneficiaries. I ended up taking her deposition in the case, my opposing counsel. It was extremely awkward to take the deposition of opposing counsel, but we had to do it. We ended up settling that case in mediation, but I kept on saying to her, what are you going to do when we go to trial? You're going to be a witness, a key witness in this case if we go to trial. And so I think the best course is to just refer everybody out and you are going to be a witness. Same as representing fiduciary who's also a beneficiary. We run into this all the time. This goes back to what we were talking about with defining the scope. Make sure you define the scope. Can you represent somebody? Yes. It's a situation where I think it depends on, are there problems? Are you going to foresee problems? Are you going to be sharing information? I mean, certainly there's potential conflicts. Representing someone who's a fiduciary and also a beneficiary. I mean, for instance, their fees, that's a common one I run into when they'll say, well, am I entitled to a fee as trustee? And as we all know, the reasonable compensation is a term that means different things to different people. So fiduciary fees, attorney's fees, sending out accountings, asking beneficiaries. I'll often have clients when there's not a conflict situation say, well, I talked to my brothers and they say they're fine with everything, and so I don't need to do an accounting. They said they'll just sign off on it. Well, I mean, that's one thing. I will kind of gauge that. You take the temperature of the situation as to whether you feel comfortable sending a waiver of accounting to an unrepresented party, and just asking them to sign off on not getting an accounting when your client is a fiduciary who's also a beneficiary of the estate. So I like to, if there's any kind of litigation matter, the best practice is, of course, to pick what you're going to do. If you were representing somebody handling an administration and then the litigation arises and they're a beneficiary, I tell people, you get another attorney. You have two capacities here. I will continue to represent you for admin matters. You can continue to use trust funds to pay me to do administration matters, but now you're over here in a dispute, an individual dispute with your siblings, for instance, that you got to pay out of your own pocket. You can't use trust funds to defend against some kind of contest, or even a breach of trust, a petition for breach of trust. They need to pay out of their own pocket. And yes, you can have separate billing and try to maintain some kind of Chinese wall, which I have done, 2 separate files, separate billing matters. But that gets really cumbersome because it is still the same person. And the average person has a really hard time understanding they wear different hats, and that they should send you 2 separate emails, for instance, one talking about the administration issue at hand and the other one talking about discovery and the litigation. So it's certainly much cleaner just to have separate counsel for those types of situations. And it goes back to establishing the scope of the representation. The last thing I have there is an issue arises, and we've all seen this, a fiduciary takes a position favorable to themselves over other beneficiaries. I would say that's a breach of the duty of loyalty. You have to explain that to your clients and try to get them to understand there's a conflict. As we all know, clients don't like, if any of you have been doing this, recommending to clients that they need to get a separate attorney. They do not like to hear that. They don't like to hear, oh, now I need 2 attorneys and I got to pay another attorney, but that is really the only way to avoid you, the attorney here, having a conflict problem down the line if something goes south.
Anne, I've just been informed by Kevin that we have 7 minutes left. So
okay.
It turns out that the introductions and stuff were kind of included. So I think we're going to do a speed round for everyone.
Yeah.
We actually have a few more than 10 slides. We have 12 slides, but I think we've covered a lot of the points in our comments so far. So let's speed round it, and we'll see what good information we can get you guys in the next 7 minutes.
Right.
So who is paying the bill? I'll just give you a quick synopsis of this situation. A third party, you cannot accept payment from a third party for one of your bills unless the client has given informed written consent to accept the payment from the third party. Attorneys, unfortunately, miss this rule quite frequently, but it's a really important one. And attendant to the issue of the third party paying the bill is the issue of whether you have the third party sign off on your engagement letter or whether you have them sign a separate document. Anne and I debated this last night. I usually have them sign the engagement letter.
Me too.
Anne does too. Yes, we debated on the same side of the debate. But, we also both have another practice that I would commend to you, which is putting in that engagement letter so both the client and the third party payer are aware that confidential information will not be shared with the third party payor. The confidentiality is only with the client, even though that person isn't the payor. Finally, Anne and I agree that, from time to time, you'll have extra funds, perhaps in your trust account at the end of the representation. And the situation has arisen where the client says, give me that money, and the third party payor says, give me that money. So yes. You may want to address that in your engagement letter. Typically, it would be the money goes back to the third party payor. So,
right. And another thing on that, another thing to make really clear is that the third party payor is not directing the representation. So if they offer to pay somebody's bill, they need to understand that does not give them the right to now direct the representation of the client. And so along with the no sharing of client confidences with the third party payor is making it really clear to them that you don't get to tell me what we're going to do. You don't get to say we're limiting anything or anything. And of course, when it's family members, that's difficult. People have a hard time with that. My mother was a criminal defense attorney until her retirement, And it would be really common for a parent to pay the bill for a child who has a criminal matter, and the parent expect that they are going to direct the representation because of that. Just because also, you know, the younger the child, the more that they think that they get to be in charge. And so it's the same thing happens here. It's certainly in cases that we have where one party is paying the bills. And I have situations that are a little bit different on this, where say you're representing joint beneficiaries in a litigation matter, and they're brothers, and one of the brothers is paying the bill for the whole representation, and they have some kind of side agreement that if they're successful, the one brother is going to pay him back. I try to stay out of those things, and I have just a standard engagement agreement that says they're joint and severally liable for the bill, even if only one of the brothers is actually paying the bill. If it's a joint representation, that's not what we're talking about here. We're talking about someone that is completely a third party who is just paying the bill and making it really clear to them that they don't share in the representation.
Awesome. So we already went over Rule 1.7 in some detail. We're going to skip that. Ann and I did want to touch very briefly on 1.9. You can't be adverse to a former client if the situation of adversity is in the same or a substantially related matter. This is the same standard that existed prior to the promulgation of Rule 1.9. That same standard was found in 3-310. It's a very, very common, perhaps the most common basis for seeking disqualification of an attorney, that the attorney is adverse to a former client in the same or substantially related matter. So if there's any question about whether you're going to be adverse to a former client, take a close look at Rule 1.9. I wanted to mention very briefly, I only have like 20 seconds here, that accompanying 1.9 is new Rule 1.10, which is the imputation rule. We didn't used to have an imputation rule. Imputation was dealt with in the case law in California, but it's a great rule, so helpful. So if you are switching firms, for example, and you want to know if your conflict is imputed to the new firm, or if there is a conflict at all that is imputed to the new firm, 1.10 will take you through those complexities. Ann knows that I litigate in 1.10 a lot. I don't have time to review it now, but it's going to give you clear guidance if you're switching firms or you're hiring an attorney from another firm. So going to the next slide.
Right. So representing professional fiduciaries and corporate fiduciaries. These are, I just want to briefly touch on this since we're running out of time. This is really common. I represent a lot of professional fiduciaries and occasionally will represent a corporate fiduciary. So they are just like any other client. And that seems to get lost. I was telling Heather, it's really common down here in San Diego. We have, a string of licensed professional fiduciaries who are the kind of usual suspects the court will appoint in conflict matters. And they know everybody. They know everybody in our local legal community, and attorneys on the other side think it's okay to just pick up the phone and call the fiduciary and ask for some information, even though that's a represented party. So you really need to be aware that they're like any other kind of client, but also there's an issue about conflicts of interest. So say you're representing fiduciary Sally Smith in the Jones Trust matter, and then you get contacted by somebody in another case in the Smith Trust matter, and Sally is involved in that case too. Sally's a trustee of a totally different trust. That is not the same client. They are acting in a fiduciary capacity, and they are separate people as far as that goes. But what has happened down here in San Diego is we have a lot of firms have developed where we'll have a notification, because you don't want to find yourself in a situation where you're representing a beneficiary and the trustee of their mother's trust is Sally Smith, and you're involved there in this hot and heavy litigation with their family members, and they like to think of Sally Smith as totally independent, and then they find out Sally Smith is your client in a different matter, and they feel like, well, you never told me that you represent this person, and how does that impact me? So So my firm, we have developed a notice that we send out to both Sally Smith and the new client in the matter, where we say, our firm represents and has represented Sally Smith in a number of matters that are completely unrelated to your matter. It's not going to impact your matter in any way. We believe that we can continue to advocate for you, but we need you to sign this form that you acknowledge that we have notified you of this relationship that we have in other business matters. And so that's one thing to do. The other one is corporate fiduciaries. I've run into this myself with some of the banks. They take a position that if you represent our bank, you can never represent a client against our bank. And that's based upon not just the business, keeping happy clients, but the allegation is you've obtained material confidential information when you represent us and how we administer our matters, how we handle distributions, how we handle our accounting, our internal information. You have learned from representing us, and therefore we are taking the position that any representation against us is going to implicate our material confidential information, and you can't do that. So you really have to make these kind of business decisions when you're taking on representation of these professional fiduciaries and corporate fiduciaries, that these things can arise later and impact then your ability to represent other clients in future matters. And Heather has also seen that with the insurance arena that she works in.
And I think Kevin said we could have a few extra minutes because of the introductions, but my suggestion would be we skip over slide 9, and it's super interesting, and we'll let you guys, study slide 9 tonight over a glass of wine or whatever. Slide 9 is gonna be fun.
I let me just make a couple comments on this, because probate is different. Probate, as we all know, requires notice directly to parties. And at all other areas of the law, you give notice, you file a motion, you serve it on the attorney. You're not sending it directly to a party. Whereas we have a whole slew of statutes that require notice directly on parties. And so that implicates the rule you have to be aware of with communication with represented parties. But also, back to the fiduciaries, what I was saying is that people contact them. There is no exception because there is a fiduciary. Don't think that there's some exception to contacting represented parties. You would still be in violation of the rule, even though they're a professional fiduciary who's neutral in the matter and you're litigating over here with somebody else. Heather?
Yeah, thank you. So now I can't hold back on communication with represented parties. I just wanted to say I had a client turned into the state bar for sending what we believed was a probate code required notice. It was alleged improper communication with a represented party. We beat it. But if you are sending that required notice, or you're doing something that requires direct communication with the represented party, indicate that you are giving it pursuant to this statute specifically, or whatever it is that requires that, because I think that will avoid your state bar issues.
That's a good tip. That's a good tip, Heather.
Diminished capacity. Ann and I could talk about this for an hour, but I don't think we have an hour. So here's the gist of it. The rest of the country has Rule 1.14, which deals with clients with diminished capacity. That was proposed in California through the Rules Revision Commission and was not adopted by the Supreme Court. The reason we suspect that it was first hard to draft and differed substantially from the model rule in California, and the reason we suspect it wasn't adopted by the Supreme Court is because California has a confidentiality impediment to the to adopting the ABA standard. Pursuant to BMP Code 6060AD, you have to keep your clients' confidences confidential even at your own peril. So you cannot, for example, if your client is lacking capacity, go out to third parties and seek assistance. It's not allowed. Now, this raises a whole variety of issues. And Ann and I were just talking about the fact that the State Bar of California, through COPRAC, which is its ethics committee, has an opinion pending for a comment, and it's formal opinion 13-0002. And it says, what are the ethical obligations of a lawyer for a client with diminished capacity? And interestingly enough, what this opinion says, at least this is my personal interpretation, is it kind of adopts the standard that was proposed in Rule 1.14 but not accepted by the California Supreme Court. But the gist of it is that you need to treat your client with diminished capacity in accordance with your obligations under the Business and Professions Code, but you may get advanced written consent to involve third parties in the representation. So client comes to you, you sign up the client. There's a provision in your engagement letter that says, you know, if you have diminished capacity or I ascertain that it is necessary to involve a third party, you allow me to disclose confidential information to X or to Y, perhaps a family member or a friend. And that advanced consent may be exactly what you need in that situation in order to continue on with your representation and competently protect the interests of that client. That's a very, very quick nutshell, but Ann, do you want to add to that before we end? And then I think we're at our time for today.
Yeah, and we do have the model rule as the next slide that you can read. That has been adopted everywhere except California. So we still are with 60/60/80. And as you know, trust and estates world, diminished capacity is a real problem. It comes up all the time. And how to address it, our hands are tied. Our hands are tied when the client, a longtime client we had, comes in and you feel like it's really clear they just don't understand anymore. And you can't just pick up the phone and call their son and say, hey, they need help. You might consider a conservatorship. We just cannot do that, even though it may be absolutely what the client needs. So I think that the advanced consent, asking the client to allow you to disclose limited information to limited persons that they trust is something that you can do. And of course, powers of attorney are so important. I can't even believe occasionally when I have a matter come in and there's a trust or a will and no powers of attorney. So definitely make powers of attorney and have multiple successor agents available because the last thing you want to have to do is a conservatorship. So thank you so much, everybody.
Thank you so much. We really enjoyed it. And again, I don't know, Kevin, if you wanted us to take any questions, we'd be happy to stay on. If not, again, please feel free to reach out to Ann and I directly at our email addresses, and we'd be happy to provide guidance, provide you with an ethics opinion or two for your reading pleasure. Thank you.
Yes.
Thank you so much, Ann and Heather. It looks like most of the participants are still on, so there's a few questions maybe we can run through, if you don't mind.
Sure. Our pleasure.
Let's see here. First is regarding conflicts. How do you handle spouses when one spouse has significant separate property?
Well, that's a different question, I guess. I mean, if the spouses can go to separate attorneys if they want to get separate estate planning and have, I like to see a separate trust for separate property. If we're talking significant separate property, I will sometimes have a joint trust and a separate property trust. And that depends on the nature of the assets and what they want to do and what the nature of the marriage is. How long is the marriage? What's the nature of the separate property? Do these people have some kind of prenuptial agreement? I mean, I don't know how significant the separate property is you're talking about, but that obviously raises a lot of issues. It's become standard, as I'm sure you all know. It used to be standard to define the separate property and the community property. My approach and the approach of my firm now is that we don't try to define what's your separate property and what's your community property. We just have clauses that what is going into this trust is all of your property. If you really feel like there's some significant assets to define, you can have separate schedules that define it. And I give notices to both of the spouses that there are ways that you can convert and transmute separate and community property, and that is outside the scope of my practice. You need to go to a family law attorney and discuss those things. And so it's certainly the same thing with conflict waivers is you define what the potential conflicts are. And if they're still on the same page, if you've adequately notified them, hey, you spouse A have just inherited $20 million worth of assets and, you know, your marital community estate was less than $1 million, this is a big deal. You should really consider how you want to handle this. And do you want to share these assets or not? I'm not going to make a suggestion one way or the other, but that's up to them to tell you, and then you document it. Document, because if they go into a divorce situation, you're going to get blamed if somebody has transmuted $20 million of separate property.
I would say this whole thing about one estate planning attorney drafting a transmutation agreement for both spouses, I have seen that in 4 or maybe 5 legal malpractice cases. I wouldn't recommend it. It just doesn't seem like there's a way to get sufficient informed written consent to handle that scenario as one attorney for the joint parties. There are certain situations in which you should just have everybody get their own counsel, and I think that's probably one of them. There could be exceptions, but the risk is huge.
Mm-hmm.
All right, the next question we have here is, what do you suggest regarding conflict waivers when doing a free estate plan for your immediate family members, such as your spouse's parents or one parent where no estate planning was done on the death of the other parent?
Wow. Well, you know, that's an interesting one, because probably the only reason you're doing free estate planning is because it's your family member and you want to have good relations with your mother-in-law, for instance. Mm-hmm. And so then you present her with some kind of conflict waiver. That's really kind of putting it that I'm not going to say adversarial, but making them think about it. Honestly, me personally, I've never had a conflict waiver when I do any kind of thing for a family member or a super close family friend that like I've known my entire life. And it's just because of the relationship, and I look at it as kind of, you know, something that if you're going to do it, you're going to do it. But there's no reason not to have the same conflict waiver you would have in any other matter. Heather, what do you agree? What do you think?
Yeah, I agree completely. You know, the biggest thing that I think so, and keep in mind that in certain instances, you need not only, you may not need a conflict waiver, but you're required to make certain disclosures. And, you know, part of my concern here is, are you a beneficiary of the estate plan of your immediate family members? Because that's going to put you in a pretty difficult situation that, you know, may not only require waivers and disclosures, but may require you just referring them to somebody else to do it. So I think that, you know, in certain low risk situations, this may be acceptable with waivers. But, you know, honestly, if we're talking about big estates, or we're talking about the potential for disputes among beneficiaries, you are probably better referring this out to a friend who can do it for a lower cost.
Absolutely. Absolutely. Don't save $500 to, you know, buy something later.
All right. I got a question about essentially third parties paying fees here is, what about a separate guarantor agreement rather than sign the engagement letter? And also, who is liable for payment, client or the payor or both?
Yes, you could definitely have the separate guarantor agreement rather than the engagement letter. That's a way that some people do it. It's not how Ann and I do it, but you want to make sure all the terms are in there, and you would want your client to see that separate guarantor agreement and probably sign off on that.
Right.
In terms of who is liable, it's just what you put in your contract. I mean, typically, you know, what I would put in my contract is, you know, you client agree that we can accept payment from your dad. You know, you give us informed written consent for that, but you and your dad are jointly and severally responsible for the payment. So the client remains liable for the payment in the event that the third party payor doesn't pay. But, you know, if you don't provide for that, then, you know, maybe you don't have recourse against the client. So it's whatever you contractually design and what they sign off on.
Right.
All right. I think we have time for one more question. In a typical joint estate plan representation, is it permitted to put in your engagement letter that after the joint estate plan is completed and that the engagement is completed, that you have the right to exclusively represent one spouse thereafter? Do you need to notify the other spouse who or who not will be represented after?
So I guess the question is, what would you be representing that one spouse with regard to after you finish the joint estate plan?
Right. And they would be a former client. I mean, there are obligations to former clients. And so the question as to, do you have to notify them of something? I think it depends on what Heather said, what the nature of the subsequent representation is. If it's anything related to or impacts the interests of the former client, then yes, you are going to have to reach out to them and possibly, depending on what it is, a written disclosure or a written consent needed in order to continue with the representation in a subsequent matter of just one of those formerly joint clients.
I mean, it's a wildly different scenario if you have the joint clients who prepare their estate plan and then you're going to represent one of them with regard to their personal injury matter.
Yeah.
As opposed to you're going to represent one of them with continued estate planning.
Right.
It depends, but there definitely may be the need for waivers or disclosures, and it may not be a good idea. Ultimately, at the end of the day, you may want to recommend that the spouse who you're not going to represent have separate counsel for purposes of the design of that estate plan.
Mm-hmm. Right.
All right. Well, I think we're all out of time, and I want to thank you guys so much for presenting to us. We definitely greatly appreciate it.
Thank you.
Thanks, everybody. We enjoyed it.
Yes. Take care. Happy Thanksgiving, everybody.